Get ready, start. Relevant portion of order dated 27/3/2015 has been quoted herein above. The main contention of Mr. Nariman, learned senior counsel appearing for the appellant, is that this order is an order passed under Article 142 or Article 136 of the Constitution and is binding upon the parties. On the other hand, it was urged by Messrs. Gopal Subramaniam and Neeraj Kishan Kaul, learned senior counsel appearing for the respondents, that the order in question is not a binding order. In the alternative, it was submitted that even if the order is binding, this court can interpret the order, and even as per the said order, the appellant is not entitled to continue with the scheme. At the outset, we may note that judicial property and discipline requires that a coordinate bench must respect the order of an earlier bench. In fact, even a larger bench should not brush aside the order passed by an earlier bench, even if it be a smaller bench, unless the order is in issue before the larger bench. Suffice to say that the order in question holds the field. It has not been recalled, and prayer for modification in IA number 10 was rejected on 13/5/2015. Therefore, the order of this court dated 27/3/2015 holds the field, and we are bound by the same. At the same time, it is our duty to decipher what was the intention of the bench while passing the order and to find out what the court intended to do by the said order. In para 2 of the order, the division bench has noted the long and checkered history of the case and has noted that the court had to take recourse to an innovative method to try and find a solution. It is thus apparent that this is an order falling within the ambit of Article 142 to do complete justice between the parties. The court was aware that the slum dwellers were suffering due to the long protracted litigation. Therefore, the court felt the need to find an innovative solution. In para 3 of the order, the court has noted the factual aspect and again emphasized the need to find a solution to resolve the various issues. The court was obviously moved by the pathetic condition in which most of the slum dwellers continued to reside. Para 4 of the order is very important because it notes the contention of learned counsel appearing for JG developers, who had emphatically stated that his client had the consent of 70% of the eligible slum dwellers, and as such the society was justified in entering into a development agreement with his client. On the other hand, learned senior counsel appearing for the appellant equally strongly refuted this claim and claimed that his client had the consent of 70% eligible slum dwellers. It is in this context that the directions contained in para 5 of the order dated 27/3/2015 were passed, wherein this court directed, inverted comma, there should be appropriate verification of the consent of the eligible slum dwellers. In Prasanti, Justice B. N. Sri Krishna was requested to verify the factum of the consent of the eligible slum dwellers. The contention raised on behalf of Susmi is that there is no mention of 70% in the direction given in para 5 of the order, and therefore all that Justice B. N. Sri Krishna was required to do was to ascertain consent of the slum dwellers in Prasanti. It is contended that almost 70% and at least much more than the majority have exercised their choice in favor of Susmi, and thus there is no reason why the appeal should not be allowed. Susmi should be permitted to carry on the development work in terms of the agreement entered into with the respondent number 3 society. It is also urged that as far as respondent number 4 is concerned, it has got hardly 30% of the votes, and Therefore, there is no question of awarding the contract to respondent number 4. We are not in agreement with this submission. It is settled law that a judicial order or judgment has to be read as a whole, and a single line or phrase cannot be read out of context. A judgment is not to be interpreted like a statute. As far as the order dated 27/3/2015 is concerned, the intention of the court will have to be deduced from the entire order. We cannot read the phrase. There should be appropriate verification of the consent of the eligible slum dwellers in presenti, in isolation. This has to be read in the context of the rival contention of the contesting parties that each one of them had the consent of more than 70% of the slum dwellers. According to us, this court was not obvious of the requirements of the Slum Act, though it may not have explicitly referred to them. It is obvious from para 4 of the order dated 27/3/2015 that Senate counsel for both the parties claimed that their respective clients had the support of 70% of the slum dwellers. Obviously, both of them could not be correct. This fact this factual dispute could not be decided in these proceedings. This was the dispute which was referred for resolution to Justice B. N. Sri Krishna. We may observe that Justice B. N. Sri Krishna, in the first effective procedural order dated 27/4/2015, rightly understood the order to mean as follows. After carefully perusing the order dated 27th March 2015 made by the Honorable Supreme Court and the submissions made in writing and through counsel and representatives on behalf of the petitioners as well as the respondents, I am of the view that the best way of verifying the factum consentum of the eligible slum dwellers in presenti would be to hold a secret ballot under my aegis, and after continuing the votes make a report to the court as to whether more than 70% of the eligible slum dwellers are in favor of the redevelopment agreement being signed with the petitioner or respondent number 4. Full stop over.